Hi, this is Jim Cunningham. You ever wonder, how do I leave money to my kids without, turning them into trust fund babies, right? How do I do this without ruining their lives? So if you're worried about this, this is great content. Um, it's a big question, right? It's a question clients ask me all the time. Hey, my kids have not had this kind of money, or I'm worried that if they get this money, somehow they're going to end up, being unproductive, not being being a productive member of society. So this is a real issue for a lot of clients. And, kind of think of it like this. Think of your child and then think of your kid and what would they do if they got a big inheritance, or what would they stop doing if they got a big inheritance, right? Or what would they not do that they otherwise should be doing? And by the way, large inheritance means different things to different people. It's like, how long is a piece of string? I don't know. It depends, right? So for some people, a large inheritance is $100,000. For other people, that's just kind of what they spend in a month. So it just really depends on the circumstances. But a large inheritance is something where you would look at that and say, I don't want that wasted, right? And that in that sense, that's what I would call a large inheritance. A big one that people are concerned about is they might be concerned about their kids. They also might not be concerned about their kids and be concerned about their daughter-in-law or their son-in-law and the influence that that individual has over a child. So that's very real. And there are ways, just this is why we're doing this. There are ways to structure your estate plan. So these are the documents that when you leave this earth and your stuff stays behind, because that's what happens, right? And we talk about that in my book, Savvy Estate Planning, which is a great book that kind of tells a lot of stories. But the idea is you leave the world, your stuff stays here, and it will go to somebody, right? It's either going to go to the government, your family, charity, other people, whatever it is. But there are things that you can do to structure your estate plan in a way to achieve your objectives of not, turning your kid into a trust fund baby. And we'll talk about what you can do and what maybe you should do. And you answer that for yourself, right? Yeah, well, maybe I should be doing this. And also things not to do. And that's kind of really important, right? Knowing what not to do. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've got over 25 years experience. I'm a certified specialist in estate planning, trust and probate law. I'm a real estate broker and insurance and securities licensed and a pilot, not current, but a pilot. So kind of a broad background on things. And these are the lawyers currently in our firm. We're getting ready to add a few more lawyers beginning next month. And a great group of people. We're all dedicated to helping families with, family wealth, family business, that sort of a thing, and structuring estates in a way to maximize tax efficiency and asset protection for heirs. If you're watching this on YouTube, go ahead and subscribe to our YouTube channel. Just click the button to subscribe. Also check that little bell that alerts you when new content comes up, which is typically every Thursday around 6 p.m. Pacific time. Disclaimer, I'm a lawyer. I'm talking kind of fast. I know. I'm a lawyer. My lips are moving, words are coming out of my mouth. This is not legal advice. And let me make this very clear. This is information. There's a fair amount of humor in here. I try to make this humorous, but don't take this as legal advice. This should be done with an expert lawyer. The stuff we're talking about here really needs to be done by an expert lawyer. So this is a real big issue. So the problem with trust fund babies. What is the problem with the trust fund baby? Well, traditional trusts, the way many lawyers write trusts, because we see them, it can lead to entitlement, a sense of entitlement. And you may know someone in your life or known someone in your life, and you're like, man, that person was horrible. They inherited a bunch of money and they were just, it really ruined them or caused them a lot of problems or really brought a lot of grief. Money is not always a good thing. Lack of money kind of is always a bad thing, if that makes sense. But sometimes money can just make some problems worse, right? Addiction, whatever it might be, those problems do get worse. And then people depend on the inheritance. And I think, this may be kind of an American viewpoint, which is, people should work and be productive members of our democracy, of our country. Like that's kind of what we were founded on is work hard and get a reward. And I think that's really difficult for people who have worked hard during their lifetime to then say, look, I'm going to turn over $1 million or 10 million or 100,000, whatever it is. It doesn't matter to this kid. That kid didn't earn it. This is like falling out of the sky, right? And for some people, they have a hard time with that. And if that's you, that's okay, because you're not alone. A lot of people do have a hard time with that. Then the other one is lack of motivation and lack of financial responsibility. I was on a call this week, actually, with a client, a wealthy client, and the son of this wealthy client is hitting mom up for money again. It's like, come on, can't you just get a job? Like, seriously. So this is a real issue, and we do see it as practitioners, as lawyers. we have to cover before we get to some of the meaningful stuff. We do have to cover. It's very short. I'm not going to bore you with a lot of IRS jargon, but there are some very important concepts that will answer a lot of questions before you even ask them, right? Before they even pop in your mind. And this is where the fine print matters. And I will tell you, lawyers write things in a certain way. People use a pejorative term called boilerplate, which I don't view as a pejorative term. These are terms that really should be in an estate plan. These are well-written terms that have withstood the test of time, withstood court cases, and it's very important not to mess with those. So it's kind of like, you just don't want to go there and customize those provisions. So I'm going to give you just two big concepts. If you give somebody unfettered, unlimited ability to control funds for somebody else, the person you give that power to may be deemed the owner of the asset, okay? And then those assets are included in that person's estate. So let's say Dan, right? Dan, who's the dad, leaves $1 million in trust for Sonny, the son, Dan's son. And at Dan's death, Tom names his brother as trustee and gives Tom the ability to distribute trust property for any purpose to Sonny. Here is the problem. Dan's brother, Tom, who's the trustee, is a related person under the Internal Revenue Code. Now, this is descendants, ancestors, and siblings. So this is not what we would call an independent trustee. This very well may result when Tom passes away, when Tom dies, the full value of the trust for Sonny being included in Tom's estate. This is a mind blower when clients hear this. And let me say this another way. You can write a trust in a certain way with certain trustees, where if you give too much power to that trustee and they're related to you or they're your employee, that can be included in their estate. And that's a really bad outcome, okay? So the other thing, so the workaround on this is something called an ascertainable standard. So Dan can leave $1 million in trust for Sonny and have Tom be the trustee, but Tom's ability to make distributions to Sonny is for health, education, maintenance, and support. Those are terms that are in the Internal Revenue Code. Those are called ascertainable standards. So as we're going through this and you're thinking, I'm going to leave some money to a kid. I don't want my kid to be the trustee of that trust, right? Because they're going to blow it. I'm going to name my brother or my sister, or I'm going to name another one of my children, okay? This is an issue you have to deal with in a trust. A lot of attorneys don't know this. So you have to be really careful on the guidelines that you give people. One solution is for the trust to have an independent trustee appointed if you want to distribute all the funds to Sonny in that case. So that's one workaround. So the solution to trust fund babies, savvy estate planning. It's in my book, Savvy Estate Planning. That's why we named it Savvy Estate Planning, because it addresses savvy estate planning, addresses a lot of these really kind of difficult issues. So thoughtful trust planning is at the core of what we do. So something to understand, if you have a living trust is like a bucket, right? It's this bucket with a handle. You sign the document, that's the bucket. The trustee holds onto the handle. You put your stocks, your bonds, your mutual funds, your house into the trust. That's what we're talking about, right? Your living trust. Now, you can have irrevocable trusts and other trusts, but for our purposes here, just to understand the concept, let's talk about the living trust. These structures, so the architecture is inside the trust, and it can be outside of the trust as well. And we'll talk about that, and we'll talk about the reasons why you may not want it in the trust. You may want a different document that's not in the trust itself. We'll also talk about incentive-based provisions. Should you include those? Should you not? I think it's good to give guidance, but whether or not you include those in the trust itself, we'll talk about why that may be a good idea and sometimes it's not a good idea. This is by the way, this is my personal view as a practitioner. Other lawyers certainly could disagree with me. So, you get two lawyers, you get three opinions, right? But I'm giving you my viewpoint from being a prior trust and estate litigator, right? I saw the things go bad. And this, the idea is to encourage personal growth and responsibility. You want your children to be happy. You want them to have a fulfilled life. You don't want them to, end up with addiction and all kinds of problems that really money either causes or exacerbates. So let's talk about the customized trust structures. Savvy trusts that don't ruin kids. That's what we want, right? We want a trust that is set up that does not cause ruin in a child's lifetime. So there are several things, several things we can do to encourage proper behavior. And one of them is establish clear goals and values. I think a lot of people don't do this in their estate plan. Your value might be, we have a ranch, and it's, we're growing, I don't know, whatever, we're growing hay, and we're raising cattle and sheep and goats. And that's really, we want to provide this sort of type of natural environment and create and grow food, whatever your goals are, but it's good to write those down. And, most people want people to work, right? I mean, there's this sort of, it's an American work ethic. There is a certain satisfaction that comes with work, with doing a job, whatever that work is. And then education. I would say most of our clients, all of them, value education, right? And especially for those of you who maybe came from more humble backgrounds, for many people, education is what lifted you out of maybe poverty, right? It's a great thing. And I think a lot of people do want to encourage education and obviously personal growth. We want to discourage entitlement and dependency on wealth. And I think, we see that a lot. A kind of high level question is, should there be staggered access to assets? And let me tell you, in the old days, which still some attorneys write it this way, many attorneys would say, the money will be held in trust. And when the child reaches 25, the money's distributed, or maybe a third is distributed at 25 and half at 30, and then the remainder at 35. That is kind of an old way of doing things. And that really strips the creditor protection that's available in a trust. So this is even for responsible, normal people, right, who don't have a problem inheriting money. They may want to keep that in a trust for some asset protection from some creditor protection. So staggered, you can stagger these or not. Just because somebody reaches 25 or just because somebody reaches 35 does not make them a responsible person. Some people are 16 and responsible. That was my youngest daughter. She could have run our whole house, age 13, right? She was just on it, getting stuff done. Not everyone's like that, right? The other advantage, though, if you are looking at staggered distributions, I would say an advantage is you can have the child participate in whatever the trust has. So if it's an investment portfolio, that child needs to kind of see, just because there's $1 million in there doesn't mean I can spend $500,000 a year for 5 years, right? I mean, the math doesn't work. So if there's $1 million in there, yeah, maybe it's 40,000 a year, or 50 or 20 or whatever it is, but it's not 100, it's not 200 really. So it's good to get them involved early on, because they may just see a lump of money and go, great, I can spend it. You would see that lump of money and go, I took a lot of effort to get that money there. And so those are the values you want to kind of impart to your children, so they just don't all blow it all. Incentive-based provisions are interesting. You can match beneficiaries' earned income. So if a child, let's say, we're in California and I happen to be in Marin County doing this. It's the most expensive place to buy a house in California. If you're a teacher, you're not going to be able to afford to live here, is the bottom line, unless you have some other source of income. So some people say, look, if you earn $80,000 a year, we'll match that $80,000 a year. Some people even go so far as to write in their trust, we'll match you, maybe we'll match you 2x, right? You make 80, we'll give you 160, and we might even pay your income tax, okay, on that 80 you're earning. So there's a lot of ways that you can use the wealth that you've created over your lifetime to really help your kids. And it really does make sense, especially in these more expensive places to live. You just can't live on these sort of salaries. It's just not going to happen. So you can condition the distributions on education. So you reach a college degree, a career, community service, it could be many things. It doesn't have to be money driven necessarily. So another part of this is the person who's receiving the money under this structure is not in control of it, right? So it's very important in selecting a trustee. Somebody needs to understand your intentions and your values. And this is something that you can commit to paper. And we'll talk about how to do that in a little bit. And then this really does foster this sort of fair and unbiased management of the trust. You are managing this trust for this specific purpose. I am setting aside $1 million for my 40-year-old daughter so that this money can supplement her earnings so that she can live in this expensive area wherever she lives. So that is one way you can do that. And it's really good to have that documented, to have your wishes committed to paper and written down. Very important. And then there's the interested trustee issue. So this is really important in choosing the trustee. It matters the relationship of this person to you. So, some people will say, well, I really want to name the sibling, which has its own issues, right? I'm not sure I would want to be a trustee for a sibling. If I had any, I'm an only child. Oh, but you might be naming your own sibling. And again, these are interested trustees. So it's, it's a bit of a tough one. Open communication with beneficiaries. This is an interesting one. I would say consider it. Don't necessarily do it. And this is something you would work on with your estate planning attorney, really your A team, your estate planning attorney, your financial advisor, not so much your CPA, but really this would be the estate planning attorney and financial advisor, the financial advisor to say, hey, this is what you have. And the attorney to talk about the family dynamics. And does it make sense to share some of this information before people inherit? The act of sharing that information can make them live their lives a different way that is maybe not optimal. So again, I would say it's very case specific. And then, the sort of transparency and accountability within the family is important because, many times families will inherit properties or businesses or whatever it is, and they kind of have to continue to work together. And so if people are hiding or lying or that can just blow up in everyone's face. So the communication is really important to foster, right, the sort of proper behavior. And then regular trust reviews and updates. This is kind of while you're living. This is very important because your family situation changes. It's dynamic. And I will tell you, the older you get, meaning, you're in your 60s, your 70s, your 80s, the more stuff happens. Now you may think, oh, when I'm retired, it's kind of static, but you've got all these people who are a generation younger. They're getting married, they're getting divorced, they're having grandkids, they're moving to different areas. A whole bunch of stuff is going on. So I would say for estate planning, people who are over 60, that's kind of a dynamic period for many of our clients. And frankly, a lot of the work we're doing is for people of that age segment because so much is changing in their life. So something to really pay attention to. I'd say review your estate plan at least every 3 years. Just look at it and then have it reviewed with a lawyer. If there's a change, or at least, kind of no more than 5 years, right? You need to have that thing looked at. So let's look at an example of Dan leaves $1 million to Sonny and names Tom as trustee. Dan writes Tom a letter, and I'm highlighting this because this is one way to do it. Dan writes Tom a letter establishing clear goals and values, right? He wants Sonny to work hard, and he wants Sonny to get an education and have personal growth, and does not want Sonny to become a trust fund baby, and doesn't want Sonny to have the sense of entitlement or dependency on wealth. Dan also gives Tom's guidance on distributions when Sonny reaches age and life milestones. Okay, well, when Sonny gets married, maybe you can give him some money to buy a house. We have a whole other webinar on how to do that, by the way. That's only one way of doing it. And then maybe when he gets his college degree, he can get some other money. Maybe when he has his first kid, he gets some other money, maybe set up a 529 for the grandkid, whatever it is, right? But these sort of life milestones, and maybe even age, right? And then this allows Sonny, the idea here is that the optimal result is this allows Sonny to mature as Sonny kind of goes through life to mature and learn financial responsibility without becoming a trust fund baby. Now, I put this in letter form. So this is a letter that Dan writes to Tom, the trustee, that the one brother writes to the other brother. You can put this in the trust. I would say here's the fundamental problem with having these detailed terms in the trust. When a person dies, when Dan dies, Sonny is going to get a copy of the trust. And if a trust is very detailed, Sonny, if he's, manipulative and less than honest, he can work it. He can look at the terms, maybe go get his own lawyer and say, hey, is there wiggle room in here? Do I really have to get this? Well, maybe I can take Tom to court and sue him and say, well, the trust said I needed to do this. And you said it, Tom, you said it wasn't good enough, but I say it's good enough. So we're going to have a judge decide. That is the danger in putting these terms in the trust itself. A separate letter to the trustee is a list of instructions. That's not part of the trust. Now, it is likely discoverable in litigation, but it's not something that Sonny is entitled to get when Dan dies. So that is, and if you're a lawyer watching this, you might say, Jim, great idea. If you're another lawyer, you might say, Jim, that's a terrible idea. You should always put it in the trust. And this is where I say reasonable minds can differ. In our firm, we tend to write letters more than put these terms in the trust. Now, I would say the exception to that is something like a special needs trust or some other trust that has these required terms in it. That's different. This is sort of the discretionary, this is sort of Dan laying out his values, about how he wants this money. Tom's really standing in the place of Dan, if you can think about it this way. So Tom needs to know what Dan's thinking. Now, the fact that they're brothers probably is more likely that Tom's going to know what Dan's thinking, but is definitely helpful to have it committed to writing. Let's talk about incentive-based provisions. Incentive-based trust provisions are found in Savvy Trust. So what are we talking about? Conditions for distributions of funds. Graduating college, get some money. Starting a business, get some money. Volunteering, whatever it is. So these are activities that the individual beneficiary can do, and they get money for it. Now, you can put this, again, you can put this in the trust or not. So what is the benefit of an incentive trust? How does it help? Well, I think it tends to, trust fund babies kind of lack motivation, self-sufficiency. A lot of this is very complex for just for everyone involved. And it's kind of nice to have some clarity, right? Whether it's in the instruction, the letter, or it's in the trust itself. Hey, if you graduate from college, you get $100,000. Great. Okay. Right. It's pretty clear. So, we don't want there's people also feel guilty for inheriting, right? I didn't earn this. I didn't deserve it. Believe it or not, people actually feel that way. I mean, if you're watching this, you might be, yeah, when mom and dad died, I got this money and it was like, they're gone. I have this sense of loss and then I get money. This just doesn't even make sense. And a lot of people too can lose their self-esteem. I know it sounds, if you have not inherited a lot of money, it may sound counterintuitive, but when you just have way more than you ever thought you would have, it can really change how you view yourself. Arrogance, obviously, that's a big one. And then addiction, that's a tough one. And lack of understanding of money, I would say, is another real, and this kind of goes to training your kids. If you have a fair amount of wealth, and again, it's what that number is, I don't know, you tell me. You got to, you should think about training your kids if they're going to inherit this, or nieces and nephews, whatever it is. But your kids, think about, hey, they might need to handle this. Do they know the difference between a stock and a bond? Do they need to know? How do they even know to hire a financial advisor? Whatever it is, these are some basic life skills in the modern world. So let's answer some questions here. We got a couple questions, and if you'd like to put any, you can go ahead and put them in the, and Ashley put in a chat there, how to help your child buy a house. Thank you, Ashley. And we have a question. Cunningham Legal drew up a revocable trust in 2016 for my wife and I. Since then, I helped my daughter and son-in-law buy a house in Montana. Congratulations. I was co-borrower and found out later I was named on the title along with my daughter and son-in-law. What happens when I die? Is this something I need to include in our trust? David, yeah. So this is a debt that's secured by the real property, it sounds like. So it's Montana. It will depend on what the deed says. That's something we can certainly help you with. We do have clients in Montana. None of our attorneys are licensed in Montana, but we have other attorneys we work with. We just bring in to help us with the Montana stuff. That's something we can help you out. David, I would just call in. You should probably include, it's interesting. There's a whole other webinar we did on how to help a child buy a house, which Ashley put in the notes there. And, if it's a gift, then, it's a gift. If it's an advance on inheritance, there's something else you have to do. So I think that's something that does affect your estate plan. So I would definitely call us and we can certainly help you with that, David. So let's look at some examples of incentive trust language. So achieving a level of education, right? The idea here is, hey, this is very detailed. I'm not going to read this to you. This goes in the trust. All right. And the idea is, look, if you get an advanced degree, PhD, MBA, we'll give you $100,000. And you can put the number in whatever you want, right? But this is guidance, right? So this says the trustee and the trustee's discretion can do this. All right. I think in this one, they just get it. So if you get the degree, you get the money. All right. And I would say getting an advanced degree, an MBA or a PhD is a pretty big deal, right? It's that not everyone can do that. Maintaining family relationships. How about distribute funds to go visit each other? Maybe you do an annual family reunion, right? And you can use that money, distribute that money from the trust for people to meet. So it's not a bad idea, right? If people wanted to see each other, because some people are living month to month and they just don't have the money to go see each other, right? It's just a little bit of a burden. So That's another one. So how do you use trust to encourage personal growth and responsibility? So now it's personal growth and responsibility. What are we doing here? The staggered distributions, right? You don't want to stunt their growth by giving them a bunch of money, right? You don't want to, hey, you're 18, here's your inheritance, here you go. Bad idea. Okay, we know what's going to happen to that money. It's going to be gone, right? So the stages can be ages, and they can be other life events, marriage, birth, you know. One thing you can't put in there is divorce. You can't say, hey, if you divorce this person, I'll give you money. That's really not an enforceable provision in California. And there are some other sort of public policy provisions. There's another one, you might say, look, I really want my child to marry someone of our family's faith. And I will, the trustee shall give the money if they marry someone of the same faith. That is not an enforceable term in California, because courts cannot interpret what's in someone's heart, and they can't interpret what someone's religion is. Or they can't decide what someone's religion is, right? That's not how we do it in America. So you would have to do another workaround. You would have to say, if you would say the trustee and the trustee's discretion could give money, right? One might be in a letter format, but that's certainly something that you could certainly work around if that was something you wanted to do. So matching funds for earned income. During COVID, it was a little tough because, a lot of people didn't have earned income, right? Maybe they lost their job. Maybe they, whatever it was. But, child makes $80,000 a year and the trust distributes $80,000 a year. So that's sort of matching or could, do 3X or whatever it is, and maybe even pay the taxes, right? So the idea here is you passed away, there's money that's in a trust, and the trustee has some guidelines on how to distribute that money. Another way to do it is to say, gee, how much do you need? Well, I need $5,000 a month. Okay, you do a budget, you distribute $5,000 a month. That's not too uncommon, right? Or whatever the number, 500 a month, whatever the number is. So you're not constantly pinging the trustee. You can have $50, you can have $75, you can have $100. You kind of work up a budget, and that actually really helps. That drives a lot of the investment decisions for the trustee. So the trustee knows, look, this is the person's age, this is their needs. How much can they take out? How should the money be invested to, statistically get us as close as we can to our goal? So again, that's working with typically a certified financial planner to run the math on that. That's some pretty heavy modeling. So here's kind of an example that you might see. Again, I'm not going to read this whole thing, but this is like in the trust itself. You could have it in a letter. You could also have it in the trust. The trustees may. It's always good to put may, not shall, because that person could have creditors. That person could have some other stuff going on. We're like, ooh, I don't want the money. May distribute, and it's based on documented earnings. Again, this is the issue I was talking about a little bit earlier, which is maybe it's good just to have this in a separate letter because it's determined on W-2 forms, pay stubs, business profit and loss statements, or tax returns. Draft tax return. You could say, well, I'm monkeying with the numbers and you kind of game the system, for lack of a better term. But again, this is in the trustee's discretion. So I think that ultimately is the best way to write it rather than shall. So again, I'm not telling you how to write your estate plan. This is maybe more for the lawyers, but the may versus shall is very important in this context. So educating beneficiaries on financial responsibility. The question is, should you share what you have? Should you share everything now? I don't know. I had a client a long time ago, and he said, should I share this estate plan, what I'm doing with my family? I said, sure. I was a very young attorney. I was very confident. He came back probably 10 years later. He goes, Jim, that was the worst legal advice I ever got. It just set off all kinds of problems. So now I'm a little more careful. Now it's a little bit like, well, you might want to do it, you might not, but you got to go with your gut on that. And, sometimes it has a negative outcome. Sometimes it has a positive outcome. So, but again, encouraging communication between trustees and beneficiaries, very important. When, in our example here, when Dan passes away and Tom, his brother's a trustee for Sonny, Tom has a duty to communicate with Sonny. A lot of trustees don't think a lot of trustees kind of get a big head, right? I mean, not professional trustees, but they might. They get a big head and they're like, I'm trustee, I'm in charge, you're the beneficiary, you're nothing. Well, that's not right. It's not correct. It's not right. And it's not correct. Meaning that trustee has a lot of duties to the beneficiary. That beneficiary has absolutely no duty to the trustee. right? That beneficiary is along the ride. The trustee has all the responsibilities and the beneficiary has all the rights. So that trustee, and if they don't do their job properly, they can be held accountable before a court, and their own funds may have to go back into that trust. So it's very, very serious business. But again, the trustees should and must communicate with the beneficiary, and regular updates and progress reports. That's very important. If you're updating, if you're bringing your family in and you're sharing this information with them, it's kind of a good idea to have a, maybe an annual meeting. This is something we do with our family office practice in our firm. Is sometimes we get the family members involved, sometimes we don't. And another thing that we see a lot of families do is around Thanksgiving. And it's a great American holiday. We're all, every American says, yeah, great, Thanksgiving. It's the one thing we all do together, that and 4th of July, I guess. So a lot of families will at Thanksgiving say, hey, let's talk about how we want to, share what we have and maybe give to charity or charitable purposes, and maybe go around the table and share what you're thankful for and talk about how to give. And that's just a good exercise at the Thanksgiving table to really show your values and helping other people, right? If you've been blessed with a lot of material wealth, I personally believe that you have a moral responsibility to share that with other people. And most people agree with that, right? So that is something that wealthier families do, and not so wealthy families, right? The people who give most of their income are, I believe, people who make under $50,000 a year. Those are the people that give most as a percentage of their income. And again, next week, we've got educating your future trustees. That's coming up. And we've already had a lot of people sign up for that. So that's very, very important. Educating your future trustee, because there's a lot to do and they may say no. Discretionary trusts. What are discretionary trusts? A discretionary trust gives the trustee the ability to decide when to make a distribution or not. That's what discretionary means. I'm going to make this distribution. I'm not going to make this distribution. A discretionary trust is not where like the trustee can give it to this one person or that other person, or, use it for themselves. That's not what we're talking about. Discretionary is, do I make this distribution to or for the benefit of the beneficiary? When you see that language in your trust, you might see it in your trust. It says to the beneficiary or for the benefit of the beneficiary. You might think, what is that? Well, that's if a beneficiary runs up a credit card. You can pay off the beneficiary's credit card, right? You can pay the beneficiary's bills. You're not paying it to the beneficiary. You're paying it for the beneficiary's benefit. That's what that term means. And, again, these discretionary trusts can be based on the beneficiary's needs, health, education, maintenance, and support, and achievements, college degree, marriage, birth of a child. The idea is here, these discretionary trusts prevent misuse of the funds, not by the trustee, but by the beneficiary when the beneficiary receives them. So if the trustee's like, I knew your parents, and if they saw what you were doing, they wouldn't want to give you any money. That's what discretionary means, that they can withhold that. My preference is that type of a trust as a drafter. And maybe you have these instructions on the side. Certainly for those who want them in the trust, we can certainly do that. But that does open the door potentially for litigation by the beneficiary in the future. By the way, that is not a challenge. So the beneficiary can say, hey, the trustee, if that trust says shall distribute for thus and such, and I've done thus and such, and the trustee says, no, you haven't. The beneficiary says, yeah, I have. That's how you get into court. So the may is a good term if you're going to have those provisions in the trust. Again, we tend to steer toward the letter to trustees. And the statement of intent in the trust itself is typically where you find that's typically in our estate plans is typically going to be kind of in the first couple of pages. That's a general statement of intent. If you're getting to granular specifics on college, it's further along in the document. So again, a discretionary trust provision basically says that the trustee, in their sole and absolute discretion, and some attorneys write sole and absolute and unreviewable discretion, which means no judge can second guess the trustee. This gives the trustee a lot of power. Now, the trustee has to use these funds for the beneficiary, not the trustee himself or herself. But again, a bachelor's degree in the trustee's discretion is reasonably likely to prepare the beneficiary for financial self-sufficiency. You see that some people say, well, I don't want you to get a degree in underwater basket weaving, even though that person may be the best underwater basket weaver in the world and a great artist. Some people say, no, I don't want that. I want it, science, technology, or whatever it is, right? The STEM stuff, engineering, math. So Another one might be paying off student loans, right? So somebody maybe racks up the student loans, which is not a bad way to go, because then that student has some skin in the game in that sense that they're taking on debt. Maybe you can pay off the student loans as a distribution. And so a lot of different ways to go. And you can say you get 50,000 when you get your when you get your college degree. It could be 150,000. I don't know. It's whatever number you want to put in there, right? But it's always going to be discretionary. So we'll answer a couple of questions, and then we'll have a couple more slides, and we're almost done. And if you have any questions, go ahead and get those, get your fingers going and put that in the Q&A, and we can answer those for you. Kathy asks, if a beneficiary has all rights, can they fire or replace a trustee? They can. It depends on what the trust says. Kathy, great question. Sometimes a trust will allow a beneficiary to replace a trustee, and sometimes it won't. In our estate plans, we typically use a trust protector if we have a continuing trust, and that trust protector can fire a trustee or not. So if the trustee's going off the rails, right, the trustee's stealing, right, not responding, and you're like, wait a minute, this person's completely gone bonkers. A trust protector can remove that trustee without having to go to court. If you have the beneficiary able to remove the trustee or not, it really does, I think, compromise some of the creditor protection aspects of having that trust for a beneficiary. And then we have another quote. Jay asks, is a discretionary trust a separate document? Interesting, Jay, these are all written in within the living trust, if you will. And then what happens is when the living trust, when the person who writes a living trust or the couple, when they pass away, if you have 3 kids, then it becomes 3 trusts. So this trust kind of morphs into 3 trusts, but this is all within the living trust. And the context here is we're talking about the living trust, but it's contained within the living trust. You can have a standalone discretionary trust. And we do see that sometime, but I would say mainly it's going to be in the living trust. So Savvy Estate Planning, check out our book. It's on our website, and it's also on Amazon, and it's Savvy Estate Planning, what you need to know before you talk to the right lawyer. All the stuff you need to know before you even meet with a lawyer. How do you find a lawyer? How do you hire a lawyer? How do you know if that lawyer's savvy? Great questions. But the idea here is we don't like trust fund babies, right? We want to encourage personal growth and responsibility, and it can prevent, it can really help to prevent this sort of the trust fund baby syndrome, and secure your child's future while promoting responsibility. We have offices throughout California, Bay Area, Northern California, Bay Area, LA, and the capital region in Sacramento. Next week, we have choosing and educating your future trustee, doing it right. This is very, very important. Many times when people are named as trustee, they do not want to serve once they find out all the stuff that they have to do. So it's definitely worth checking out. And you may even want to forward this to the person you've named as trustee. All right, because there's a lot going on here. So subscribe to our YouTube channel. You can hit the subscribe button. Just keep watching this on YouTube because it's going to roll to the next video.